Tonight, challenging birthright citizenship. Last week, Tennessee Attorney General Jonathan Skrmetti joined 23 other state attorney generals in challenging this principle.
We spoke with an immigration attorney last week, and tonight we hear from AG Skrmetti. News 2's Kelly Milan reports.
For more than a century, the United States has treated the act of being born on its soil as enough to make someone a citizen. Tennessee's Attorney General Jonathan Skrmetti says that interpretation may have grown far beyond what the founders intended.
I think somebody who had voted for the 14th Amendment, who had voted to ratify it, would probably be pretty surprised by how broadly the citizenship clause has been read.
General Skrmetti has joined a coalition of 23 attorneys general, urging the Supreme Court to revisit the 14th Amendment citizenship clause and the precedent that defines it.
The assumption at the time was that, if you were just passing through, you didn't know any allegiance to the country, you were going to go back to the country to which you were loyal. I think they would have thought it was a pretty strange thing for somebody to get American citizenship just because they happened to be here when they were born.
The brief argues the framers of the post-Civil War amendment never intended citizenship to apply to people merely passing through. Instead, he says, they envisioned it for those who owed allegiance to the United States and made their homes within its borders.
The Constitution, the 14th Amendment, talks about residing in a state. And, if somebody's deliberately passing through just to have a baby, get citizenship, and leave, that doesn't seem consistent with the language of the amendment.
Many immigration advocates say the effort is political. Skrmetti insists the push is not, but simply an attempt to restore faith in law and help policymakers argue immigration on solid ground.
It's plainly a legal issue. It's talking about what the words in the Constitution mean.
He also says this is a push to clarify what he calls an open constitutional question left unresolved for more than a century.
And the question really is, what limits does the language of the law actually impose?
The Supreme Court has not yet agreed to hear the case on its merits, but Skrmetti expects movement soon, possibly a hearing within months and a decision by summer. I'll send it back to you, Bob and Haley.